All right.
We don't need one for sub.
Oh, okay.
All right. Good afternoon, everybody. Thank you for bearing with us. We're going to go ahead and get started. We've got a busy committee day. So anyhow, Representative Byrd, if you'll open us in a word of prayer. Which number are you? Well, we need to record it.
25.
Okay, go ahead.
If we all bow our heads, please. Heavenly Father, we thank you for this beautiful day, the sunshine, the cold. While we are in this room, may we be just, kind, and doing what's best for the people of Georgia. Give us each wisdom, knowledge, and the understanding of what's presented so that we knew we are doing the right thing. Thank you for all that you do, all that you are, and all these things in Jesus' name. Amen.
Thank you. First bill we're going to hear today is House Bill 993. Representative Williams. Leave it. Yes, sir. Go ahead.
Because I know we have a number of people that want to speak and maybe they can just use the podium. Thank you for the opportunity to be here today. Just wanted to bring before you House Bill 993. This bill came to my heart because of the lawlessness and the crime against law enforcement officers. Just a few weeks ago down in Jones County, Gray, Georgia, we had a deputy made a traffic stop, and as he approached the car, the person in the car shot the deputy right off. The deputy never had a chance to say anything to the person that he made the traffic stop on. This is uncalled for. It's got to stop. Just a couple of days ago, right here in Atlanta, a police officer making an arrest, 22-year-old, takes a gun and shoots that officer 9 times. Mr. Chairman, members of the committee, I have loved ones, relatives, friends that are law enforcement officers serving in the House of Representatives with former officers. And I just feel like we've got to send a message. It's not going to be tolerated. You do the crime, you're going to do the time. And that's what my bill intends to do. If you shoot a law enforcement officer performing his or her duties pursuant to Article 6 of Chapter 8 of Title 42, by shooting a gun at and causing physical injury to such law enforcement officer, you shall be found guilty of a felony, and upon conviction thereof shall be punished by imprisonment for not less than 10 or more than 20 years. And I know there's going to be some language added that we want to make it a mandatory sentence. And at the proper time, we'll have that amendment and other people speak on that. But I'll stand for any questions. Thank you.
Thank you, Representative Williams. Representative Saines.
Thank you, Mr. Chairman. Thank you, Representative Williams, for bringing this forth. I join you in your feelings of how serious this kind of crime would be. As a former Georgia peace officer, let me ask you on line 19. So is this specific to an individual that were to shoot a officer versus cause deathly injury in another way? I just wanted to walk through the logic. I'm not disagreeing with you. I just wanted to understand that better.
Well, by shooting a gun at and causing physical injury to such law enforcement officer, you know, this officer that was shot down in Jones County, thank goodness he had his vest on, and the vest did stop the bullet from penetrating and injuring him. He has some bruised ribs, but anyone that attempts to harm a police officer, law enforcement officer, whether it's through firing a gun at them or stabbing them with a knife or anything else, they should be charged with attempted murder is what I'm after.
Okay, I was just trying to clarify that line. Thank you.
Thank you.
All right, any more questions from the committee for the author at this time? Representative Byrd.
Thank you, Representative. Just curious, I know that I think prior to me arriving here last year, there was a hate crimes bill done. Would that be correct?
Yes, ma'am.
So would this also be considered a hate crimes or not, please? And what was it before? If this bill weren't presenting today and you're making it a felony, if someone shot a police officer prior to this, what is it? What is the crime?
Prior to this, it's an assault on a law enforcement officer. And I know the prosecuting attorneys council are here and they can clarify some of your question. But prior to this bill, they're just charged with assault.
Thank you.
Thank you.
All right. Oh, we've got several signed up to speak on this one. All right, let's see. Let's hear from Mazzy Lynn from Georgia Association of Criminal Defense Lawyers.
Afternoon, Chairman and committee. Thank you so much for hearing from us today. I actually have what I think is potentially good news for you, Representative Byrd and Representative Saines, based on your questions. Today in Georgia, because of the General Assembly's support of law enforcement through the Back the Badge bill several years ago, this was a bill that then Representative Reeves carried here in the House and Senator Harper carried in the Senate. If a police officer is shot on our streets today by anyone 17 years, by an adult, that person faces a mandatory 10 years in prison, up to 20 years in prison. Actually, this bill as drafted, and I understand Representative Williams to say that there's an amendment coming, but as drafted, this is actually a lighter penalty than what someone would face today for that same behavior. And the way that would work, we would actually be very okay with, because that would mean that the person that is prosecuted and convicted would get this lighter sentence. So it would be our position that, Representative Williams, this issue is well covered in the law already. It's actually a harsher penalty right now. And in addition to an aggravated assault, if a police officer is shot, it also represents an aggravated battery on a police officer. And that carries a mandatory minimum of 3 years. And those, even if it's, and I did confirm this with my colleagues at PAC this morning, even if it's a single shooting, I would not do this. I'm the child of a law enforcement officer, 31 years retired. So I have great respect for the vocation as well, and actually the profession, I should say. But if I were to take a gun and shoot an officer, I would not only have committed an ag assault on a peace officer by pointing the gun, but when the bullet injured them, you could constitute an aggravated battery on top of it. So you have the mandatory 10 on the ag assault, the mandatory 3 on the ag battery. And I gotta say, the judges in our state have the discretion to go up from there, of course, up to 20 years on the aggravated assault and up to another 20 years on the aggravated battery. And I would dare to say that they are exercising that discretion fully. I believe the sentences are probably adequate, but they certainly have plenty of time to work with under current law to punish someone who is convicted of this kind of behavior right now. But I would stand for any other questions that you might have.
Yes, I actually have some. If you look at the bill as drafted, and we're working off of LC 480508 right now. If you look at the bill as drafted, you'll see in lines 18 through 20, prevent any law enforcement officer from performing his or her duties pursuant to Article 6 of Chapter 8 of Title 42 by shooting a gun at and causing physical injury to such law enforcement officer. That is the proposed change. If you go and you look at Article 6 of Chapter 8 of Title 42, there's several statutes cited within there, and it's concerning Department of Community Supervision and probation officers. My question is this. If you look at Code Section 16-10-32, you will note that in Section A, subsection 3, it covers law enforcement officer. Now, my question to Gackel, and I would appreciate Pat weighing in on this as well, is it then, and for the author as well, I've got a threefold question here. Was it the intent, or was there an issue, may I ask that first? Was there an issue that we were afraid that Department of Community Supervision and probation officers were not considered law enforcement or included in that definition of Section A, subsection 3 of Code Section 16-10-32? It seemed to be in the preamble and within this bill itself that this was relating to all law enforcement officers, but then we single out the Article 6 of Chapter 8 of Title 42, which includes Department of Community Supervision and other officers that are associated with parole and supervision of those that may be under probation sentences. So my question was this: is there a concern of the author first that probation officers, Department of Community Supervision, that they weren't adequately protected under OCGA 16-10-32?
Well, Mr. Chairman, I'm no attorney, so my concern is to protect all law enforcement officers, whether they're pardons, parole, even DNR who are in law enforcement.
Correct. Okay. Ms. Mazzellan, would you like to weigh in on that?
I would, sir. Thank you. So with respect to the aggravated assault on a peace officer, the way the way it is worded is it's a public safety officer. The definition of a public safety officer is found at 16.5.19. And I know that there was an attempt to include as many people as possible, though I will admit DNR officers are not included in this particular definition. A public safety officer under 16.5.19, which applies to 16.5.21, is a peace officer, a correctional officer, emergency health worker, firefighter, highway emergency response operator, jail officer, juvenile correctional officer, or probation officer. So it does not cover the DNR folks, but I also don't believe the language of the current draft would cover them either, because it limits it to law enforcement, and that's not defined as anything to include a DNR officer, but I would defer to Ms. Parker for sure on that. I don't see a definition that includes DNR for, yeah.
And this is just for clarification, because in reading through the bill, it looked as if the intent was for all law enforcement officers to be included.
That is correct.
We want this protection, obviously. But in looking, it seemed to me, and it was confusing upon inspection and reviewing that code section as to whether probation officers were being left out by having been included. Maybe legislative counsel could speak to that, wherever, whatever reasoning that was singled out for that.
Just, I was attempting to cover law enforcement, and it was just trying to be area where there were several other statutes that were defining specifically branches of law enforcement. That was not, but again, this can be changed
Sure. Okay. Mazalyn, we'll come back to you in a second. Pat, we'd like to hear from y'all on that, just to verify. And the same question goes for y'all.
He's welcome to join me at the table if he wishes.
I am frantically trying to pull up my statutes as well right now.
That's fine. I'll give you time.
I've got mine. Thank you. I think that one of the things we're running into is what a peace officer, a public safety officer, you're upon 16.5.19.
Because I was talking about it.
Because that's where the definition of peace officer, and there, a public safety officer means peace officers. The problem is where the definition of peace officer is found, that's in Title 35. And I think that in the definition in Title 35, it would reach DNR because it talks about anyone who's employed by the state or any subdivision thereof whose primary job is for law enforcement. I apologize, that's a paraphrase of what's found in Title 35. I believe it's in the Post Act, which would be 35-3-8.1, I think. And I apologize for not having that site handy. Our quibble with this bill is we're perfectly fine with the author's intent and support it fully. The only thing we have is that right now in the aggravated assault code, which is 16.5.22.1, under the back of the badge, a bill from a couple years ago, this body raised the punishment and said, if you commit an aggravated assault on a law enforcement officer and you're over the age of 17, then it's a 10 to 20, and the first 10 you cannot be probated, suspended. You have to go to prison for those 10 years. And we're simply asking that those punishments that are an aggravated assault be carried over here, that you don't reward someone with a lighter sentence for attempting to kill a law enforcement officer with a gun. If basically the idea is that we can prove intent to kill, in terms as this bill does, you shouldn't get a lesser penalty than you would for just merely shooting at, in, or in the direction of a law enforcement officer.
So the bill as written, in your opinion, would create a lesser cause or lesser penalty. And let me clarify this for probation and DCS officers.
Yes, sir. I agree with my friend from Gackel that this makes it a lighter punishment.
Okay, so that would need to be changed. Now, to get back to my question, though, in Article 6, Chapter 8, Title 42, is that limiting language there? Would that limit it to probation and DCS officers? And I know that y'all might want to, and I can give you time to look at those, but that has been my concern in looking over the bill and trying to accomplish the intent of the author.
I'd have to research that. I don't know off the top of my head, and I apologize for not.
No, that's fine. That's fine. I'm all right with giving homework. That's fine.
Second day in a row.
I know. So my question is then to you, Mr. Smith, as a prosecutor, is what the author of the bill he's trying to accomplish here, can that already be accomplished under current code sections dealing with officers who are being shot at, threatened with violence? Is that already covered under our existing statutes?
The internet is moving. The interwebs are moving slow. I mean, do you have 21? I'm looking at aggravated assault. The question is those officers, the DCS officers, the DNR Rangers, I think it's Rangers now, if they are public safety officers, because that's the 16.5.21C1 language is anyone who knowingly commits the offense of aggravated assault upon a public safety officer while he or she is engaged in or on the account of performance of his or her official duties. So that's, the question is, what is a public safety officer? And I'd need a minute or two to be able to give you an intelligent answer to that question.
Sure. And I'll allow that. I will say, bear with me all for just a minute. if you look in section, or excuse me, OCGA 16-10-24, you will see that a game warden and juvenile probation officers and your adult probation officers, I guess you could say, prison guards, jailers, correction officer, community supervision officer, that is very well encompassing as far as the obstructing or hindering law enforcement officer. So my question is this: by providing a more expansive definition of who law enforcement is, spelling it out in the statute, and knowing what the author has testified to as to his intent, not necessarily creating a new code section as this bill would, providing a section 4, but amending OCGA. And I know that's a compound question, but indulge me. Just by editing section 3 of OCGA 16-10-32, it seems to be that may very well accomplish what the bill author is trying to do.
I'm going to quote your code section back.
Okay.
And once again, thanks to my friend from Gactyl, 16.5.19. That's the definitionals for the assault and battery chapter, or crimes against a person. And 16.5.19 says that a public safety officer, now remember, it's aggravated assault against a public safety officer. It says public safety officer means peace officer, which is the expansive, these are the people that post has to certify, correctional officer, emergency health worker, firefighter, highway emergency response operator, jail officer, juvenile correctional officer, or probation officer. So all of those folks are covered inside the aggravated assault code. Now, to your question about if you were to go in and make that change to 16.10.34, I don't know with certainty, because that's, I don't have a crystal ball. I can tell you what the books and how we're trained to think about a statute. And when you say that you want it to be specifically applied to one group and don't use an expansive definition to include others, it's an intentional act to exclude them. Meaning that if you say that you want to do everything, you're trying to legislate against blue cars, that means all the other cars that are not blue are not included. So in this instance, by specifically referencing those officers in Title 42, you're doing that. An argument could be made, I'm not saying that you are, but an argument could be made that you're intending to not include the others. Does that answer your question?
Yes, that's fair. And it seems as if, just using, for example, 16-10-24, the obstructing or hindering law enforcement officers, this is just solely for the purpose of pointing out just what we have discussed here. We do need to specify which officers there are that are included in there. Not just to say law enforcement officer doesn't seem to cover what the bill author would like us to cover and what we need to cover.
I agree with you on on hindering or obstruction. Yes, sir. That is because there's a term of art that's used in that code section. So it has been read to exclude certain folks who wear badges on behalf of the state of Georgia.
So is there any reason we should exclude those who wear certain badges in the state of Georgia from this proposed code section? In 16-10-32.
That's a policy decision, and if y'all so choose to do so, that's the law that we swear an oath to enforce and prosecute on behalf of.
Right. Okay. Representative Sains.
Question was for a little earlier ago, but in terms of, I don't know if the question for DNR is still, if that's been answered, but my DNR agent, just to make sure I'm clear, a law enforcement DNR agent would be part of a peace officer there. They have general jurisdiction, but where you noted, I think you said parole officer. I know that it's now been updated to a community supervision officer, but the point that doesn't say probation, if we're using the old language, would it have needed to say parole and probation, or is parole all encompassing because it had jailer?
We may have to look at that. Because that gets to my point earlier about when you have a list of things and you don't have certain things. And that might just simply be, as you noted, that we've changed some of our terminology for the officers. So we may have to go through and clean up the code. And this might be an opportunity to do that.
Thank you. Hang tight. Terry Norris, if you want to speak to this, because I want to hear from y'all's side what's going on with this. If you're prepared to testify,
I am, and I'd like to defer to one of my 159 bosses, Sheriff Ron Freeman from Forsyth County. And
Of course.
indulge us. He will be a much better, off a much better testimony.
Yeah, Sheriff, we're glad to have you with us. Thank you for making the time. If you would like to really comment on what you've seen and following the discussion we had, and then I'll get to whatever comments you had, but just to come in here to this conversation we're having, are you finding that there are not adequate laws on the books to prosecute those who are shooting and trying to kill, maim, harm our officers in this state?
Well, Mr. Chairman, I would say this to that comment you made is aggravated assault is a well-rounded statute that exists. It's good. It's written. Obviously, it's widely used. Unfortunately, widely used. But it covers threatening an officer with a bat is aggravated assault against a peace officer. Holding a knife and saying I'm going to cut you is. I would make an argument as a sheriff and representing 498 of my own employees and speaking for the sheriffs. When you take a firearm, and I've said it 1,000 times, we don't have a gun problem. We have a criminal with a gun problem. When you take a criminal with a gun who points a gun at a law enforcement officer and fires that weapon at them and tries to take their life, I would argue that is a uniquely distinct category of assault. That aggravated assault is a broader, and granted there are mandatory statutes within aggravated assault for against a peace officer, but I would argue that that is a unique and significant step of violence taken knowingly against a law enforcement officer. And obviously that would have to be proven in a court of law that it was taken knowingly and actively with intent to do those things. So I think from that standpoint, I would believe that there is an opportunity here to address the worst of the worst criminals that are trying to take law enforcement officers' lives.
So your opinion is we don't have sufficient laws on the books to punish that kind of conduct of, say, somebody finding out where an officer lived and riding by and shooting up their house or shooting at them when they come out?
So we're left with aggravated assault. And again, that is a broad statute, necessarily so, I believe. And I think, again, I don't want to parrot what I just said, but I think the severity of this calls for a uniqueness, whether that was a subsection under aggravated assault or whether that is a new statute is for this body to determine. But I understand, as my understanding of the author's intent, kudos to that and for standing up for that. I was on the phone with a sheriff this morning who had an officer shot yesterday. And so it is becoming far too prevalent from a repeat violent criminal offender. And so I think we should have some pretty significant statute that deals with that most violent offender and that most violent act against a law enforcement officer, because the only thing we're left with is the officer actually losing his life.
Thanks, Sheriff. Any questions from the committee for the sheriff? Representative Sains.
I want to echo what the sheriff said on the unique distinction of aggravated assault. And I do want to echo the concerns of what we heard from Gactel, though, in if we do have a parallel charge, that it's not a lesser charge than is already on the books.
Any other questions from members of the committee? Sheriff, thank you for joining us today.
Pleasure. Thank you, Mr. Chairman.
Feel free. I know you invested your time to come down here. And we're glad to have you and we support you 100%. So thank you.
Thanks, sir.
Yes, sir.
Thank you, Sheriff.
Thank you.
Thank you.
So I guess the question still remains, just this body in the past, and this is for PAC and Mazalin, this legislative body in the past has increased the penalty for officers. So I'm trying to see this, whether we have, this is the question. The laws on the books, are they not specific enough to cover all law enforcement officers? And is that what we need to change to make sure that the code section penalty in 16-10-32, I think that's that mandatory minimum of 10 years. Do we need to make sure that applies to everybody? Because we've talked about DNR.
Right.
DNR, and I know most other officers are probably this way too, but DNR most assuredly, just about everybody they're going to come up on is armed and, they're armed and ready to go, so to speak. So if that is something that we also need to clear up in the language, because I'll go back 16-10-24. I mean, it specifies out who all these officers are. And maybe it is a code revision, but is that?
I don't think so. So I've had a chance to look at the definitions, and I would want to loop Mr. Smith in too, and I guess I hear you, Chairman, speaking to 16-10, 20, I'm sorry, I'm losing the number now, 24. I know it's not usually my organization that stands here to say there's already something harsher on the books that we'd prefer you stick with. I mean, obviously we'd prefer this lower one, but the definition of peace officer. So I'm going to take us back again to ag assault. And I did hear the sheriff. I think I understand what he's saying with respect to having a sense that ag assault is kind of I'll call it pedestrian crime. It's applicable in a lot of situations. That is true, it is. But in Back the Badge, this body particularly singled out a more aggressive sentence structure when the victim in that case is a peace officer, a public safety officer. In the definition of public safety officer, we have peace officer. The definition of peace officer is found back at 16.1.3 at 16.1.3.11. And it's defined as any person who by virtue of his office, I would argue should have her in there, or public employment is vested by law with a duty to maintain public order or to make arrests for offenses, whether that duty extends to all crimes or is limited to specific offenses. It seems to me that the intent of that statute is to include, to your point, DNR officers, anyone that would be vested by law with this duty to maintain public order. And it gets away from the problem that Mr. Smith was describing, where when you try to get too particular about the individual job titles, you run into trouble of excluding people. Whereas this definition is very inclusive. And I think my folks would have a hard time arguing that DNR is not included in this or any other law enforcement officer.
So I do have a question, may as well pack both. Want y'all to weigh in on this. You come to the issue of what about the rule of lenity in our court, and I'll just read a brief summary of what that means. The rule of lenity directs courts to resolve such ambiguities in favor of a defendant. And those ambiguities consist of ambiguities in the code section. So in certain code sections, we have specified which officers this applies to. And I know that Mr. Smith had noted the nuance within 16-10-24, I believe it was. But in examination of this, and I appreciate Representative Williams bringing this forward, because I don't know if we'd have had this conversation. We've got multiple definitions of law enforcement officer and who that I mean, to me, when I think of law enforcement officer, I think about everybody from the head of the state patrol, GBI on down to our local city police officers and community supervision, all in between. That would be what I would understand by just using the term law enforcement, but it gives me great consternation when I see different code sections in our criminal code specifying which law enforcement officers are covered. And then I would agree with interpretation. Law enforcement officer covers everybody. But then you have this cited in the bill concerning probation officers, Department of Community Supervision. So I appreciate Legislative Council bringing this up too, now that we've got this all out in the air. So is it needful for us to specify that, just do with the rule of lenity? Because we sure don't want people who are trying to harass and in most cases kill our law enforcement officers. We don't want to jeopardize convicting those bad actors.
Well, I think so. The definition that I was reading to you of peace officer, which is one of the itemized individual categories within public safety officer, comes from 1613. The set of definitions that's in 1613 does apply to the entire title. So even when we're in 1610-24, if peace officer is used, this definition at 161311 is going to be the definition that applies, unless, there are times within each chapter where a new definition is listed and applies only to that chapter, or only to that code section. There are times when that happens, but as a rule, this initial set of definitions at the beginning of the title are going to apply throughout. And I don't personally, Robert may have a different, Mr. Smith may have a different point of view, but the definition of peace officer that's included here doesn't seem to me to be a problem with lenity. But if he feels like, it's probably better that he answer that question.
Sure,
because-
sure. Mr. Smith.
And what I fall back to is from the aggravated assault code, the definition and I don't want to say out of turn, but I believe Senator Kirk was the sponsor, and we made, and the person who may have helped draft that bill may be maybe a friend and a coworker of Miss Gertlin. Apologize for butchering your name. Public safety officer means peace officer, correctional officer. I kind of went through that before. Within that, then it redefined, because one of the questions that was asked was about, well, we've changed the name. It's no longer the probation office, it's the Department of Community Supervision. And if you read what a probation officer means, it's somebody working for juvenile justice. There's a reference in here to, correctional officer means anyone appointed by the Department of Corrections or the State Board of Pardons and Parole. There's an attempt to make this a very broad definition. Their probation officer means a community supervision officer, county or Department of Juvenile Justice probation officer. So the language was written, and the back the badge bill was very expansive. It was intended to scoop up pretty much anybody they could think of and protect them, so that if someone used, if someone committed an aggravated assault upon them, this enhanced punishment would be available to prosecutors and to judges as a tool. The author's intent here, and I don't want to speak for him, if it's the will of this committee, the will of this legislature. If you create a new law, that's the only reason why I'm here and speaking is, if you give us a new tool, make sure it doesn't conflict with the tool we already have. And that's all I'm asking, is that we don't, and the chairman read the thing about lenity. When you have when you have the same conduct or conduct that could be deemed to be equivalent, and punishments are different, as you said, it has to be resolved in favor of the defendant. And, and that's the fair thing to do. That's the right thing to do. And in this instance, if there's a lower punishment, we have to go with that.
I'm going to go back to one of my first questions. Are there laws on the books sufficient enough to prosecute the kind of conduct that's been testified to here today? Or do you need that additional tool? And I say need, not want.
I'm going to defer to answer that question, because that's not my job. That's your job. That's the legislative decision to determine if we need these tools. That's your job is to make the laws. My job is to prosecute on behalf of the state.
Right.
So if you want to give me a tool, I'll gladly accept it. If you think it's already encompassed somewhere else, I'm going to give you a thought or give you an opinion on something, and I
Sure.
have. But whether or not I want it or need it, that's for you to determine. That's not, you've been elected by the good people of the state of Georgia to make that determination.
And I understand that. It's just my question, and maybe we need to reach out to some of our local DAs, but it's just, there is such thing as prosecutorial discretion in this state as well. So that is my question. I mean, you know, there's a difference in a hammer and a claw hammer and a claw hammer with a rounded tip, a framing hammer, and just your regular old household hammer. And so if there's something we could make it to where if you've just got that household hammer and you need a sure enough framing hammer, we can do that. So we just want to make sure here, it's just, do you need a better hammer or do you need something totally different? Because the amendments to this code, I mean, it would seem to the chair that we could amend part 3 of section A in 16-10-32 and achieve what the author intends to. Is it needed though? That's the question. So Representative Williams, I know you're tight on time. You've got an important committee meeting to go to. It's a little homework assignment because I want to make sure that it's not just prosecutorial discretion that is the problem here. Because I'm sympathetic to this.
Right.
Got family in law enforcement and don't want them being subjected to this kind of violence that we've been seeing. So I want to make sure it's not and no offense to prosecutors. I know Mr. Smith's one of the best we've had in the state and many others are, but I want to make sure it's just not the discretion that is not being applied in the right way. So thank you for your bill. And I asked that y'all would get y'all's heads together and see what y'all can come up with. Thank you.
Thank you.
And if you were signed up to speak on this bill, whenever we pull it back up for another hearing, I'll honor y'all being here to speak on it. It's just Representative Williams has an important education committee to get to apparently. Thank you. Next up, we have Representative Gunner, House Bill 1140 or 1183, excuse me.
Oh, okay. Yes, sir.
I'm sorry. Oh, okay.
Judge. Afternoon, Judge. Let me get you hot and on my. All right, go ahead. Afternoon, Judge.
Afternoon. Thank you for having us, members of the committee. House Bill 1183 is a bill to clarify the criminal bonds. When the principal doesn't show up for court, these statutes apply and determine how much the bondsman is going to forfeit, if any, and it lays out the rules. This bill clarifies that. But in prepping for today, we've noticed that there's a few things that we want to take out of it. I've asked Judge Taylor to come up here with me. He's a much brighter mind than I am, and I think he'll explain some of the parts of the bill that are going to come out of it or change. Section 1 was not intended to be in there. That was my mistake for not getting that out. But Section 2, I think is where the meat of this bill is, and I'm going to turn it over to the judge.
All right. Thank you, Representative Gunther. I know you've oversold my intellectual capabilities, but thank you all for allowing me to be here. And I'm happy to answer any questions y'all have. As Representative Gunter talked about, this chapter deals with when a defendant doesn't show up to court, out on bond, doesn't show up to court, and the court issues a bench warrant and forfeits the bond that was put in place when the defendant was originally arrested. And so the surety, the one who's put up the money on that bond, has responsibilities. And the way that the statute, I believe, was intended to work, and there was I should say this statute's been in effect for many years. And then I think it was 2013, it was revised. And it went through a number of iterations and then came out with a final revision. And I believe what ended up happening was that this code section, which I had on the top of my head, let me see here, it's 17,631. Had some inconsistencies built in, or I'm sorry, 17,672. Had some inconsistencies that got in there that made it really, it just couldn't be applied the way it was written. And so what this bill is intended to do is to fix that. That's all it's intended to do. The intention, we believe, of the legislature, and this was a judicial council. Originally, it was something that was brought in from the judicial council. I know we've had discussions with folks from the bonding companies and their folks, and they are in agreement with this, that the intention is simply this, and I'll walk down through quickly and I'll answer any questions otherwise. Within 120 days after the entry of judgment. So if somebody doesn't show up, there's this bond. The judge, there's time periods within which the judge, before the defendant was to appear, enters a judgment on that bond and enters a judgment as to the surety to surrender that bond. Within 120 days of that, under the new revision, if the surety finds that principal, meaning the defendant, returns that principal to the court to appear before the court, they're only required to pay 5% of that bond amount of the judgment. That's it. They pay 5% because they found them within 120 days. They pay 5% of that actual judgment. If, however, they're not able to find that principal within 120 days, they have the ability to pay the full thing, the whole judgment, the entire bond, and to apply for an additional 120 days. So they do that. They pay it. They apply for an additional 120 days. And if they find that principal within that additional 120 days, or that principal, and return them, they get back 95%. If they find them, if it takes them longer than that, so if it takes them longer than essentially 240 days to find them, within 2 years, they'll actually get 50% back. And so that's what the intention, I believe, of subsections D and E written together were intended, but it's not the way they were originally written. So this is to clean up, to make sure that the intention of the legislature is followed. And that's why you'll see the provision. I don't know if you have any questions. I don't need to go. If you want me to.
Change.
I will. Yes, sir. The only change, and Representative Gunter picked this up, I'm not sure how it happened, but in subsection E, in E1, you'll see it's if within 120 days from entry of the judgment. 2 should have that same, it should use the same language, but it doesn't currently on this draft. So it should say, the court, 2A should say, the court shall direct that the judgment be marked satisfied and that the writ of fiery fascius it be canceled if within 120 days from entry of the judgment. Because E is designed, it's kind of, the statute was written kind of backwards, but E is the initial period of that 120 days.
Mr. Chairman, the idea behind this is to give incentive for the surety to go after these folks and bring them back to court. The way it's written now, it doesn't really do that. So that's why we've made these changes.
Any questions from members of the committee? All right. Do we have anybody else signed up on this bill? I know there were some people coming in late. Doesn't look like it. Judge, first of all, thank you for taking time out of your busy day. I know y'all are swamped right now, and we appreciate you coming over here and testifying before us. We like to say we're the most important committee in the House. So we welcome you and thank you for your testimony. You're welcome anytime that you want to come see us again, whether it be testimony or just to come and check up with us. We thank you very much.
I appreciate that. I was happy. I had 3 trials scheduled today, and I ended up with none of them went forward with trials. I had 2 dismissals and 1 plea, so I was able to be here and I was happy to be here. So thank you.
Divine intervention, one might say. All right, thank you.
Thank you.
Representative Gunner, sounds like there's some language that needs to get cleared up on it, so.
Yeah.
I'll do my best to have another subcommittee scheduled if you want to get with legislative council and make these changes, and then we can vet it a little bit more.
Yes, sir.
With the changes made to it, because I know it might be a little premature now. I appreciate y'all mentioning those changes, but
Right.
once y'all get that, just get it to me and we'll get you a hearing on it.
Yeah, we'll have a final draft of that pretty soon. I'll let you know when we get it.
Okay. Thank you for bringing this.
Yes, sir. Thank
Thank
you.
Y'all have a good day. Rolling along. Next up, we have Senate Bill 226 by Senator Jason Anavatharti. You can sit at either the table or the podium, whichever you would prefer.
Good afternoon, Mr. Chairman.
Afternoon, Senator. Good to see you again. You can go ahead, Senator.
So we are here discussing LC 480514S. This is a committee sub that I know, Mr. Chairman, you and I have talked about, and also Chairman Burchett. I think there were some tweaks related to, I think, a copyright concern or issue. Those have been addressed. I think there were some improvements in terms of parent participation at school board meetings. But this goes back to the underlying bill of addressing information and obscene material in schools.
Okay, and Senator, just to make sure we're operating off of LC 480514S.
Yes, Mr. Chairman.
Okay. All right. Any questions from members of the committee? I know we vetted this pretty hard the first go around, but are there any questions from the committee present with us? Representative Byrd.
Thank you, Senator. Just quickly looking through this, are we still just talking about what happens in schools and the obscenity in libraries at schools, or any curriculum, that sort of thing? Nothing to do with an outside library?
No, we are only talking about in a K-12 setting. Yes, ma'am.
Okay, thank you.
Thank you. Good question.
Any questions online? All right. Anybody signed up to speak to 226? Taylor Hawkins. I believe you were here last time and didn't get a chance to speak. Now we will make up for that. Just introduce yourself and tell us who you with.
Yes, sir. My name is Taylor Hawkins. I'm the Director of Advocacy for Frontline Policy Action. We are the largest pro-family policy organization in our state. Obscene materials have been a huge concern for people all over this state for a number of years, and we're very grateful to Senator Anavatharti for bringing this bill. It's a very important piece of legislation. The main concern, of course, is the parents who are not being heard. Parents have had concerns in different schools across the state. Those issues have been addressed in schools, but the process for parents to do that right now is very, very uneven from school to school. It varies, and some schools have shut down parents' concerns without ever hearing their concerns over these issues. This committee heard detailed testimony on this issue before, and we really appreciate the dialogue that is taking place around this issue. Current procedures, as I said, have been proven inadequate, and the need for this clarification has been brought to light by all those parents whose concerns haven't been addressed. And this bill does not open up broad liability across the state, but rather just ensures that parents have the right to be heard on this issue, which is of vital importance to them, the exposure of their children and our children in the state to obscene materials. Transparency that this bill provides, we believe, is crucial to protecting children. and protecting children from in a place in their schools, which is crucial that they not be exposed to this material and that they be free to learn and expand their minds and be able to empower them for future prosperity in this state. This bill passed Senate last year, has already received the approval of this committee once. And so we're asking on behalf of families from every corner of the state that you pass Senate Bill 226 again and protect our students in this state from obscene materials. Thank you, Mr. Chairman.
Okay, we got any questions from members of the committee? All right. Representative Byrd.
Thank you very much. Just want to make sure that I understand what you just stated, that parents would have the ability to lodge their complaints against a school system and there would be action taken as opposed to not listening what they have been told.
Yes,
I
ma'am.
come to a school board meeting, I make my complaint, and then the school board just goes away and does nothing to my complaint. So this is going to have that effect
That's
if we
correct.
vote on SB 226 today.
Yes, ma'am. There have been numerous incidences where parents have brought up sometimes multiple pieces of material that are available, even as low as some elementary schools and middle schools in the state. And their concerns have been, and not necessarily through the fault of the administration. We don't want to allege motivation, but their concerns have not been addressed. Gone 6 months, 12 months, 18 months without any resolution of this issue. And the problem with that, especially in this circumstance when we're dealing with this issue, is that those materials still being available means we are presenting challenges because other students are viewing those materials. Other students are experiencing the trauma of their innocence being robbed, in a sense, if you could say, because of what this material is doing as it continues to be available.
Further question, please. So I'm looking at each local board of education will be able to adopt their own rules as opposed to the state making a very broad statement for each school system across the state of Georgia.
It's going to, what it's going to do, as far as I understand the legislation currently, it's going to make sure that there is a policy in place, because currently there are schools that have no policy whatsoever. So there are schools where this is urgently needed, and then those policies can be, addressed if we find issue with those at a later date.
Thank you.
Yes, ma'am.
Looks like we don't have any more questions for you. Next, we have Brother Mike Griffin from Georgia Baptist. He may have went to lunch being Baptist. He's what?
He's not able to make it.
Okay. All right. All right. Let's see. Miss Desiree Jones, I believe you're here. If you'll just identify who you're with and.
Sir. Thank you so much for having us, Mr. Chairman. My name is Desiree Jones, and I'm the Policy Associate at the New Georgia Project Action Fund. We are a nonpartisan organization that does voter registration and civic engagement, and I'm here to speak against this bill. We find that there is already recourse for parents to lodge these complaints. Parents have every opportunity to talk to their schools, talk to librarians and media center specialists in schools to lodge any complaints they have about any obscene materials in books. We also think that this bill is too broad in the way that it defines obscene materials. Books like 50 Shades of Grey are not available in our K-12 schools anywhere in Georgia. There are young adult novels and things that have some mature content, but this not obscene content. These are things that we're exposing our children to so that then when they go out into the world, they're not shocked by the fact that there are people who do drugs. There are people who have sex. These are not foreign concepts for Georgia students. And we feel that by learning things through books and through reading and having these things accessible in their schools, we are actually setting our students up to be more successful and being able to use discernment. I think that by going ahead and doing a blanket ban on different things, you're not teaching kids to use discernment. You're teaching them to be afraid of things. You're teaching them to judge things and to have fear. And that isn't something you should be encouraging in students. We should be encouraging our students to actually experience things and make informed decisions based on their experiences. And we see this is already happening. There are already books being banned in schools, and these books are largely by people of color and queer people. And I don't think that that's something that we want in Georgia, not having our students exposed to the experiences and thoughts of people of color of queer people because they exist in this world and they will be exposed to these things as they leave Georgia schools. As they matriculate into our colleges and universities, they will be exposed to these things. And by taking that opportunity away from them in our schools, it is harmful. And I know that there are people who've said things like students can just go to outside libraries. That was my phone. You can just go to outside libraries or they can buy books. And that just isn't, that's not true for a lot of students. We all know that Georgia doesn't have public transportation everywhere. There are students who aren't able to get rides to the library. There are rural libraries that don't have the same resources and have access to the same kinds of materials that school libraries may have access to. And so, yeah, I really do feel like this is not something that's necessary. I think it's reactionary to something that isn't happening. And we should not be instilling fear and judgment into our students, but should be encouraging them to flex their muscles a little bit and actually get to make their own decisions and not have their parents step in because they're afraid of something their kids might be exposed to, because that's not the world we live in. These things are going to occur and pop up for them anyway. So happy to take any questions that y'all might have.
Any questions from members of the committee? Don't see any.
Thank you.
All
Yes,
right,
ma'am.
Representative Byrd.
Thank you very much. Just curious, I want to be sure that I clearly
Yes, ma'am.
understood what you just said. That number one, that this does not transpire any obscenity in our schools currently.
So I'm not saying that, I think the definition that the bill uses for obscenity, and I want to make sure I'm using the language, patently offensive to prevailing standards in the adult community as a whole in what respect is with respect to what is suitable for minors. And I don't think there is an overarching adult standard of what is appropriate for minors. I think that every adult has their own idea of what that is. And by imposing a more restrictive view, that might be actually causing students to not have access to things they could have access to, and experiences they could have access to. And yeah, I don't think there are not obscene books in Georgia schools. I think there are things and themes that some people might find a bit mature, but I think that librarians and media specialists are not letting just blatantly obscene things into their libraries in their schools.
So just further
Yes, ma'am.
follow up, just to be sure. So parents, as far as I'm concerned, should make the determination whether their child is in fact receiving or
Mhm.
reading obscene things in a school.
Mhm.
So are you suggesting that the school itself make those decisions as opposed to a parent?
So in the bill, it does talk about how library specialists already have the ability to decide what is stocked in their school libraries. And so they have the ability to stock things that they feel are appropriate for students, but parents can always, talk to their own child. I think that's kind of the thing that is missing in conversations about this bill is the parental responsibility. We've heard a lot about that this session, especially with the parents' bills of rights that are going through the different chambers. If parents have these concerns, I think they need to be talking to their kids. You need to talk to your kids about things you can't find appropriate. My mama didn't let me watch a lot of shows that had violence in them when I was little because she was like, that's inappropriate. You shouldn't be watching these things. And so she told me that, and it didn't happen. And so if parents have concerns about their kids reading things about that have violence or drug usage or anything like that, they need to be having those conversations with their students. I don't think it means the school doesn't need to have them available for those students whose parents are fine with them reading that content.
Okay, thank you.
Yeah.
Chairman Burchett.
No, thank you for your testimony. I don't have a question. I have more of a statement. Do you know where those words you read come from?
I do.
Patently offensive?
Okay, so I don't think the bill online is the proper LC number.
It is. Do you know where,
it
do you know where those come from, those words you read?
Line 23
Yes.
or 21, I'm sorry.
Do you know where that's from? That standard is the Supreme Court standard for what is obscene. That's why this bill is in our committee. So I just wanted to put that on record.
Well,
Thank you, Mr. Chairman.
I appreciate that. I really do appreciate that context. But that doesn't change my statement at all. I still stand by everything I've said. Thank you.
Thank you for your testimony. All right. Terence Wilson, you with us?
I've already had the opportunity to speak, so I'll be very, very brief.
Okay.
Sorry, I should wait till I get to the podium. Good afternoon. My name is Terence Wilson. I'm the Regional Policy and Community Engagement Director for the Intercultural Development Research Association. We are an education nonprofit that's focused on equal education opportunities for every child. So I spoke to the committee last time we had an opportunity about some of our concerns related to some of the First Amendment protections, as well as our concerns related to the provisions in the bill already being in current law. But I did not get a chance to get to the last piece of my testimony, so I just wanted to share that with you all, is that we are concerned that under the current processes, this measure will inappropriately limit the material that covers topics that explain and address themes from individuals with marginalized identities. And these identities include racial and ethnic minorities, LGBTQIA+ individuals, and religious minorities. This concern has been borne out by several other states that have enacted provisions similar to this Senate bill. And I just wanted to, just as a little bit of evidence, read you some of the books that have been banned. According to the American Library Association, so they have a list of the top 10 challenged books of last year. One of them is George by Alice Gino, which was challenged, banned, and restricted for LGBTQIA+ content. Another one was stamped Racism, Anti-Racism, and You by Ibram X. Kendi because of the book contains selective storytelling and does not encompass racism against all people. There's another book that was banned and challenged based on it contained a political viewpoint that was claimed to be biased against male students and against police. So I think that although the concern of this committee is laudable around obscene materials, we would like for there to be protections for those kinds of minorities, for religious minorities, for folks from the LGBTQIA+ community, and for folks from racial and ethnic minorities, that their materials and that the students in our schools still have access to those materials, and that they are not unnecessarily removed from the school shelf. So those were the additional comments I didn't have a chance to raise with you all last time. So I appreciate the time to be here today.
Thank you, sir.
Any questions?
All right, at this time, I'll entertain a motion. Got a motion? All right. Second motion. Yeah. Is there a second?
Second.
Got a move or second. All those in favor say aye.
Aye.
All right. Those opposed say no.
No.
All right, the ayes have it. Moves to full. Thank y'all very much, everybody, for your patience today. Senator, we will have full committee at 3 o'clock. So, yep. TBD. Thank you.
Thank y'all.